Macedonia's Journey Towards EU Membership by Abdullah Azizi in the International Journal of Social Sciences and Humanity Studies. Introduction. Since 2005, the Republic of Macedonia has been a candidate for European Union membership, which the country's government considers its top strategic priority. It is currently among the 5 remaining candidate countries, alongside Iceland, Montenegro, Serbia, and Turkey. A significant hurdle in the accession process is the unresolved naming dispute between the Republic of Macedonia and Greece. While Macedonia prefers its constitutional name, the Republic of Macedonia, the European Union recognizes it only as the former Yugoslav Republic of Macedonia, a provisional reference established by the United Nations in 1993 to address Greek concerns. As a long-standing EU member, Greece holds veto power over new accessions and has consistently declared it will block Macedonia's membership until the naming issue is settled. Since 2008, resolving this dispute has been an official EU precondition for accession. There are also bilateral conflicts with Bulgaria, primarily due to differing interpretations of their shared 19th and 20th century history and issues regarding the ethnic distinctiveness of the two nations. Bulgaria, which joined the EU on January 1, 2007, expressed reservations about unconditionally supporting Macedonia's membership. In July 2006, Bulgarian Foreign Minister Ivalo Kalfin and President Georgi Parvanov raised concerns about negative and aggressive attitudes towards Bulgaria and its history promoted by Macedonian authorities. These concerns were met with defiant responses from Macedonian political leaders. In October 2012, for the 4th consecutive year, the European Commission recommended initiating membership negotiations with Macedonia. However, Greece had vetoed the start of these negotiations on each previous occasion, and in 2012, Bulgaria also used its veto. Progress on resolving the long-standing naming dispute appeared promising when, on October 4, 2012, the Greek Foreign Minister proposed a draft Memorandum of Understanding. According to the Euractiv website, the Macedonian Foreign Minister responded positively to this proposal on November 8, 2012. Stefan Füle, the European Commissioner for Enlargement and European Neighbourhood Policy, suggested that the easing of stances by both countries might enable accession negotiations to start even before a naming dispute compromise is finalised. On December 11, 2012, the Council of the European Union decided that Macedonia could begin accession negotiations as early as the second quarter of 2013, provided it reached agreements on its disputes with Bulgaria and Greece. The Council was optimistic due to recent progress on the Greek dispute facilitated by a UN mediator, Macedonian Institutional Infrastructure for European Integration. The Macedonian government has set up a management framework for European integration based on a 1997 paper titled The Strategic Basis of the Republic of Macedonia on Achieving Membership of the European Union. This framework includes the following institutions. 1. The Committee for Euro-Atlantic Integration. This central decision-making body for the European integration process is chaired by the Prime Minister and the Deputy Prime Ministers. Its members include all government ministers, the Governor of the National Bank of the Republic of Macedonia, and the President of the Macedonian Academy of Sciences and Arts. 2. The Working Committee for European Integration of the Government of the Republic of Macedonia, WCEEI, chaired by the Deputy Prime Ministers, responsible for EU integration. This operational, interministerial body includes secretaries from all ministries. It establishes methods and dynamics for implementing strategic decisions, political guidelines, and government priorities, while also monitoring the execution of specific tasks. 3. The Deputy to the President of the Government. This role focuses on managing and coordinating the operational aspects of the integration process, supported by the Sector for European Integration within the General Secretariat of the Government. 4. The Sector for European Integration, tasked with organizing, coordinating, and synchronizing the EU integration process. This sector is divided into 7 units responsible for aligning national legislation with EU laws, translating EU legal acts, institution building, supporting the WCEEI, coordinating foreign assistance, and informing the public about the EU and the integration process. 5. Departments or sectors, units for European integration within ministries. These have similar structures and responsibilities as the central sector for European integration and serve as key links in the institutional framework. 6. The Ministry of Foreign Affairs, EU domain. This ministry handles communications with EU structures through the mission of the Republic of Macedonia in Brussels, gathers timely information impacting the integration process, and presents unified perspectives and positions to European institutions. Additional institutions supporting the EU integration process include the Republic's Assembly and its Commission for European Issues, the Secretariat for Legislation, the General Secretariat of the Government, the Subcommittee of the WCEI for Approximation of Legislation with its working groups. The Secretariat for European Affairs in the Macedonian government has developed an institutional platform for EU negotiations. This platform outlines the responsibilities of various participants in the process, including the national delegation, negotiation team, working groups, heads of the working groups, the chief negotiator and their secretary, relevant ministries, the Secretariat for European Affairs, the Ministry of Foreign Affairs, and the Macedonian Parliament. Conditions for EU membership and accession process. The EU has rigorous approval procedures to ensure new members can fully participate. To be admitted, candidates must comply with all EU standards and regulations, gain consent from EU institutions and member states, obtain approval from their citizens, either through their national parliament or a referendum. The Treaty on the European Union states that any European country respecting the EU's democratic values and committed to promoting them can apply for membership. The initial requirement is meeting the Copenhagen criteria, established by the European Council 1993. These criteria are stable institutions that guarantee democracy, the rule of law, human rights, and respect for minorities, a functioning market economy capable of handling competition and market forces within the EU, the ability to adopt and effectively implement the EU obligations, including the goals of political, economic, and monetary union. The EU retains the right to determine when candidate countries can join and must ensure it can integrate new members effectively. The EU sets stringent criteria for membership to ensure that new members can fully meet the responsibilities of EU accession. This involves adherence to all EU standards and regulations, which are categorized into 35 distinct policy areas chapters for accession negotiations. These standards are non-negotiable. Candidates commit to adopting and implementing them according to agreed timelines and effectiveness, providing the EU with assurances of compliance. Before membership negotiations can commence, unanimous approval from all EU member states is required through a decision by the EU Council, which establishes a negotiation framework or mandate with the candidate country. Negotiations are conducted in an intergovernmental conference format involving EU government ministers, ambassadors, and representatives from the candidate country. Upon the recommendation of the EU chairman, the Council of Ministers decides unanimously to initiate negotiations with the candidate country. Negotiations commence only if the state has met the Copenhagen political and economic criteria, as confirmed by the European Commission's recommendation on a negotiation start date. Once the negotiation start date is set, an intergovernmental conference is convened. This conference involves the participation of EU member states and the candidate country. EU member states are represented by their foreign affairs ministers, chaired by the Council of Ministers chairman. The candidate country is represented by a specialized delegation authorized to negotiate, typically led by high-level political figures such as the Foreign Minister or Minister for Euro integration. These negotiations occur at a professional and expert level, aiming to establish unified positions for resolving outstanding issues. The highest-level conference convenes every 6 months. If the conferences operate at the deputy level, the EU side is represented by members of COREPER, ambassadors, while the candidate state is represented by the head of the negotiating team. The Intergovernmental Conference is chaired by the EU member state, holding the presidency. The official start of negotiations begins with the opening session of the Intergovernmental Conference, hosted at the Council of Ministers headquarters in Brussels or Luxembourg, depending on the scheduling in April, June, or October. During this session, the head of state or government of the candidate country and the foreign minister of the presiding EU member state exchange formal greetings. During deputy-level meetings of the Intergovernmental Conference (IGC), EU member states are represented by their permanent representatives in Brussels, while the candidate states are represented by their chief negotiator. Sessions occur monthly, involving national delegations. Negotiations for each chapter are guided by the following processes. Screening. The European Commission collaborates with the candidate country to conduct a thorough assessment of each policy area, chapter, to evaluate the country's readiness. The Commission presents its findings chapter by chapter to the EU member states through a screening report. Based on this report, the Commission recommends either initiating negotiations immediately or specifying certain conditions, opening benchmarks, that must be fulfilled beforehand. Negotiating positions. Prior to the commencement of negotiations, the candidate country submits its position, and the EU formulates a unified position. In most chapters, the EU defines closing benchmarks within this position that the candidate country must achieve before negotiations can conclude in that specific policy area. Negotiations on each policy area are only considered complete when all EU governments are content with the candidate's progress, assessed by the Commission. The entire negotiation process concludes definitively only after all policy chapters have been closed. The speed of negotiations hinges on each country's pace of reform and alignment with EU regulations. The duration of negotiations varies. Beginning negotiations concurrently with another country does not ensure simultaneous completion. Throughout the negotiations, the Commission oversees the candidate's adherence to EU laws and fulfillment of other obligations, including meeting specified benchmarks. This provides the candidate with additional direction as it prepares for EU membership responsibilities, while also assuring current members that the candidate is meeting accession criteria. The Commission ensures ongoing communication with the EU Council and European Parliament throughout the process, delivering regular reports, strategy documents, and clarifications regarding conditions for continued advancement. The accession treaty is the formal agreement that solidifies a country's membership in the EU. It includes specific terms and conditions of membership, transitional arrangements, deadlines, financial details, and any safeguard clauses. The treaty becomes legally binding only after approval by the EU Council, the Commission, and the European Parliament, signing by the candidate country and representatives of all current EU member states, ratification by the candidate country and each individual EU member state, following their respective constitutional procedures such as parliamentary vote or referendum. Upon signing the treaty, the candidate transitions into an acceding country. This status signifies its anticipated full membership in the EU on a specified treaty date, contingent upon ratification. During this interim period, the acceding country enjoys certain privileges, including the ability to provide feedback on draft EU proposals, communications, recommendations, and initiatives. Additionally, it holds active observer status in EU bodies and agencies, granting the right to speak, but not to vote. Conclusions. The political aspiration for Macedonia to join the EU has not translated effectively into improvements within the country. For Macedonian citizens, The establishment of a negotiation start date for EU accession offers hope for escaping their challenging social, economic, and political circumstances. Despite the anticipation, this process is expected to be lengthy. Over the past 2 decades, citizens have awaited a better future that has yet to materialize. The country continues to grapple with internal issues such as democracy, the rule of law, administrative politicization, and interethnic tensions. External challenges, including disputes with Greece over the country's name and with Bulgaria regarding Macedonian identity, must be resolved before negotiations can commence. Assessing the current situation suggests that this accession process will likely be protracted. In essence, advancing the negotiation process for Euro integration demands genuine dedication and a pragmatic approach to addressing real challenges. Moreover, progress in negotiations necessitates harnessing all available resources and engaging new talent from beyond government institutions to contribute effectively to this effort.